There we go. Can you please, Shannon, can you please proceed with your presentation?
I will, and thank you very much, and thank you for considering this very important bill about public interest expression. I have lived experience as an individual who practiced for decades as a regulated health professional in Winnipeg. My voice was silenced following protected disclosures under the Workplace Safety and Health Act and the Public Interest Disclosure Act beginning in 2013. I was assured that I was protected against reprisal. I was not. As a regulated health professional, being unable to report health and safety issues that in my case were later validated by the Government of Manitoba Labour Board in 2018 and by Workplace Safety and Health in 2019, but required to continue practicing while effectively gagged under a non-disclosure agreement and settlement agreement between the Manitoba Nurses Union and the Winnipeg Regional Health Authority. It created a great deal of moral distress, conflicted directly with my professional and ethical obligations as a registered nurse. And it is a fact that public sector healthcare employers and bargaining agents for regulated nursing professionals are settling grievances by way of agreements that include oppressive non-disclosure agreements, one-sided releases, favoring employees that make union members vulnerable to reprisal. Regulated health professionals cannot practice while gagged, and it is to reinforce how that's happening. There are provisions in collective agreements between public sector healthcare employers, Winnipeg Regional Health Authority, Shared Health, Prairie Mountain Health, all the RHAs, and the Manitoba Nurses Union. This is the article that allows this to happen. Manitoba Nurses Union, Article 1311, nothing in this collective agreement shall preclude a nurse or, not and, or the union committee and the employer from mutually agreeing to settle a dispute by means other than those described in the grievance and arbitration procedures, or to extend any of the stipulated time limits. CUPE's agreement is even worse. CUPE Local 2348, those are the social services sectors, so the most vulnerable sectors, and the healthcare sectors. CUPE Local 500 Riverview. In their collective agreement, 1108, it says nothing in this agreement shall preclude settlement of a grievance by mutual agreement in any manner whatsoever. That contract's out of the contract. Those provisions are unconstitutional. They're resulting in settlement agreements between public sector healthcare and social services employers and bargaining agents who just don't have equivalent bargaining power. The overwhelming majority of nurses, in my case, it was nurses, are women, female, members of marginalized groups. More than 90%, according to credible public sources, including the Canadian Institute of Health Information and the World Health Organization, to name just a few. Regulated nurses to this day, I know because I've been defending litigation because of a non-disclosure agreement between the WRHA and the Manitoba Nurses Union since 2014. And we're now finally have sought leave to appeal to this Supreme Court of Canada. This is a pressing issue in Manitoba. There's no place, zero place, for non-disclosure agreements between the Winnipeg Regional Health Authority, the Manitoba Nurses Union. Nurses cannot be intimidated, threatened, gagged, and forced to practice that way because that's a threat to public health and safety. If they can't report, patient safety suffers. So by having had this sort of legislation existed, and it should exist, I spoke a couple of years ago, actually, and I was assured parliamentary protection, and there were reprisals after. But I spoke to the issue of non-disclosure agreements between government reporting entities like the Winnipeg Regional Health Authority, Shared Health, And I'm not the only nurse who, another nurse was sued actually for a breach of an NDA right before I was. And I'm still in court defending it all these years later. The Manitoba Nurses Union was never served notice. They're a party to the agreement. So I guess what that means is the Manitoba Nurses Union is also gagged by the Winnipeg Regional Health Authority. And that situation is intolerable, can't stand. So any legislation that preserves the voice of somebody like me, like the nurse that you might see today if you or your loved one goes to the emergency room, they can't be under a gag order, and those gag orders can't be enforceable. In addition to violating provincial health and safety legislation and professional and ethical code of conduct, it's actually a violation of the Criminal Code of Canada. You can't intimidate, threaten, or interfere with a regulated professional or healthcare worker in the course of their duties. So please pass this bill or something like this bill to protect future generations. We have a critical shortage of nurses, and there's no way of knowing how many of them are practicing today under a gag order. Thank you for your time.
Thank you, Ms. Hancock. Are there any questions? Minister Wiebe?
Yeah, thank you, Ms. Hancock, for your presentation, and thank you for your work as a nurse. Obviously, we appreciate our healthcare workers so much, especially these days. So thank you so much for your work. I appreciate that you've had a chance to look at the bill. I do hope that the legislation that we're passing assists you without knowing some of the details about your case, but I do hope that it assists you in making sure that you feel protected. It's really about protecting the vulnerable. So thank you again for laying out some of your concerns and some of your support.
Ms. Hancock, do you have a response?
Yes, and thank you very much. I appreciate that. It's every little bit helps. And there's been a culture of, there's a lot, there's like parallel universes. There is the talk about transparency and accountability and safety and freedom, and health professionals can speak. And then there's the reality of nurses who are practicing today under gag orders. And so I've been defending myself for all these years, and just because nobody wanted to challenge the practice of gag orders. So I got as far as the Court of Appeal, got obstructed there. So I'm now seeking leave to appeal to the Supreme Court of Canada. And I've actually served a copy of the notice on the Attorney General for Manitoba by way of Deputy Attorney General Jeremy Ackerstream. It's such an important issue, and every nurse in this Manitoba Nurses Union is not the voice for all nurses. It's the only voice you hear, but they are not the voice for all nurses. And their collective agreement is very different from the collective agreement for registered nurses on faculty at the University of Manitoba. They'll never be in this position because of the difference in their collective agreements and their collective bargaining power. MNU needs to revisit their collective agreements, because a change to that provision would change the entire situation. You can't contract out of a contract. Again, thank you very much for your time. I don't want to belabor the issue or beat a dead horse, but I do appreciate your time.
Thank you. Any questions? Mr. Balkin?
Super. Well, thank you, Honorable Chair. It's a pleasure, and thank you, Ms. Hancock, for your presentation. It's very important process that we follow here to make sure that we get public engagement, and I appreciate everything that you brought forward. Having a wife that was a nurse, my mother-in-law is a nurse, and my daughter is now practicing as a nurse, I appreciate your candor and bringing this forward. Thank you.
Thank you. Any response?
Yes, thank you very much. And thank you to all the nurses in your family, and to anybody who loves a nurse or needs a nurse. You don't ever want the nurse that answers your call bell at 2 a.m. to be under a gag order and sued and threatened by employers that are funded by government, which has been my experience for the last 10 years. So I'm here to change that, and that's the goal. Thank you again. And I hope you all have a good evening. Thank you.
Thank you. Are there any other questions? Seeing none, we will move on. Thank you, Ms. Hancock. Thank you. Now we go on to Bill 23, and I would like to call upon David Grant. David, can you please proceed with your presentation?
Okay, thank you. Bill 23, based on the prior presentations, seems like a great bill here. We've needed this bill for a long time. Unlike one of the other people who found a problem with a paragraph, I was just so shocked to see it there and so glad that it's going to be helping to encourage people to speak publicly, that I didn't nitpick and look for a problem with it. I just love it the way it is, and it's so much of an improvement over what we have. I'm hoping that it'll encourage more people to do what's sometimes is called whistleblowing, although the public speaking doesn't have to be that. Too many good folks in Manitoba know of malfeasance and want to report it, but they also know they can be victim to prosecution and other vindictive stuff. I've suffered some of that. Ms. Hancock, that spoke before, has experienced that to a much greater extent. But they still want to do the right thing. Until the protections offered in this bill become law in Manitoba, and until the good folks who want to speak out in public know that they are protected, much is wrong with our corporations and institutions will not be fixed. So I have great hopes for it. I was elected to serve on a very important bill, on a very important board. Well, there I discovered much that was wrong. I was able to use normal board processes and motions to correct some of these. In one other case, 10 years ago, I spoke here to Bill 21. I followed the organization's rules for board members speaking in public. We were restricted to only speak in favor of actions of that board. So it was an action of the board 2 years before, and I spoke here in favor of that action of the board. The person who didn't like me speaking then decided that no member of that board could ever speak in public, which is pretty different, because what happened is the board had made a rule that the organization could make charitable donations to registered charities. Bill 21, 10 years ago, said the organization could make donations. I saw a big difference there, registered charity or just donations to the next door neighbor. And that's what I spoke to, is having Bill 21 incorporate what the board had already passed. Anyway, that was seen as a huge violation of trust, and so they hounded me for a while, and I ended up having to run away. Anyway, the Bill 23, if it had been in place, would have made it simpler for justice and public interest to prevail. Ironically, in that the act that governed that organization, Section 56 says that no action shall proceed against somebody acting in the public interest. So they ignored their own act to harass me and chase me out of the organization. So that's something else that I'm not sure how you deal with that in Bill 23. If some organization has such crazy leadership, draconian leadership, that they're going to ignore their own rules, are they going to ignore Bill 23? So just offer that as a cautionary tale that even where there's a protection built into an act, which is good, bad people may still harass good people when they're doing the good thing. So I can leave that to you. And thank you very much, so much for bringing this bill forward. And I look forward to it becoming law.
Thank you, David. Questions? Minister Wiebe.
Thank you very much, Mr. Grant, once again for your presentation. And nobody knows public advocacy like you. You're here for all the committees, and we appreciate that. And protecting your voice in all ways that we can, I think, is important. So thanks again for your presentation.
David?
And in response, I would point out that there are a lot of cases where people needed this, and once it's well known, and again, maybe that's something that one of your people can look at, whether the things that happened to Ms. Hancock could happen after this bill is law. Will people still get away with doing nasty things to good people? I would hope not. And if there's a way of rewording some small part of Bill 23 to make sure no nasty people do bad things after this. So thank you, and thank you so much for bringing it forward.
Thank you, David. Mr. Balkin?
Mr. Grant, thanks very much. I know you've appeared at any committee that I've been at and certainly bring good perspectives forward. Appreciate you attending committee all the time and having your voice heard. So thank you.
Mr. Grant?
It's not just a hobby and retirement. It's I've been involved in provincial politics for 60 years now. In the old days, it was just helping get the Premier of Ontario elected and stuff, but it's been a lifelong hobby of participating and trying to make things better, because you guys are how Manitoba is going to get better, both sides, and anything I can offer to help is definitely worth my time. And thank you very much for the time here.
Thank you. Any further questions? Thank you, Mr. Grant. I would like to now call Ms. Heather Fast. Oh, can I stand? Oh, no, it's okay, sorry. Ms. Fast, please go ahead with your presentation.
Thank you. Good evening, everyone. My name's Heather Fast, and I'm the Policy Advocacy Director at the Manitoba Eco Network. The Manitoba Eco Network is a nonprofit registered charity which seeks to strengthen Manitoba's environmental community with the goal of protecting our environment for the benefit of current and future generations. I'm a lawyer and a legal academic who spent a long time working with the grassroots community to find ways to improve access to justice in Manitoba. So I'm extremely pleased to be here today to support the passage of Bill 23, the Public Interest Expression Defense Act. Bill 23 will create a new legal pathway to protect citizens speaking up about matters of public interest and discourage the use of litigation as a means of limiting discussion and debate. This type of frivolous lawsuit is also often referred to as a strategic lawsuit against public participation, or a SLAP suit. Anti-SLAP legislation like Bill 23 is an important mechanism for improving procedural justice, ensuring those advocating for public interest do not feel intimidated or afraid to speak up. I've been seeking the adoption of anti-SLAP legislation in Manitoba, modeled after the ULCC and Ontario's Act, for many years, both through my work at the Manitoba Eco Network and my academic studies as a PhD candidate, which have focused on identifying legal mechanisms that can be adopted at the provincial level to facilitate access to justice for Manitobans. Unsurprisingly, anti-SLAP legislation is often recommended as a means of protecting citizens from frivolous lawsuits. Community members have spoken with the Eco Network about their fear of legal repercussions for speaking up about public interests. For example, we've heard from citizens who've received cease and desist letters for making a Facebook post about their environmental concerns. Many citizens will discontinue their advocacy activities when faced with the legal threat, as the potential legal and financial burden is extremely overwhelming. The adoption of anti-SLAP legislation like Bill 23 will help strengthen the ability of Manitobans to advocate on behalf of themselves and their communities without facing severe legal and financial consequences. Anti-SLAP laws help protect vulnerable citizens, such as survivors of gender-based violence, when they disclose or report the violence they have experienced. Anti-SLAPP laws also protect those who study, report, and publish about matters of public interest from being intimidated or silenced by costly, time-consuming lawsuits. The Manitoba Eco Network has had a number of great discussions over the last few years with the Department of Environment and Climate Change about our policy and law reform recommendations and the need for anti-SLAPP legislation such as Bill 23. We appreciate the time that's been spent listening to us, both by Minister Schmidt and Minister Moyes. Bill 23 has also given the Eco Network the opportunity to build a new connection with Minister Wiebe and his staff at the Department of Justice and discuss our thoughts on the bill. It's nice to feel heard by the Manitoba government and see action being taken to protect public interest advocates. However, there is one big problem with Bill 23 that I hope can be fixed today. Section 4.2 of Bill 23 could result in situations where, when a legal proceeding involves an injunction, the filing of a dismissal motion under Section 3 of the Act will not pause the proceeding, even if the injunction ends up being meritless. We think this exception weakens the protections offered by the bill. There should be an opportunity for the proceeding to be paused, even when injunctions are involved. As a result, we recommend removing Section 4.2 from the bill. Our engagement with Minister Wiebe and his team seemed to demonstrate a clear interest from the Department of Justice in improving protections for those speaking up about public interests. Next week, when I deliver the lecture on public advocacy to my law students that I rescheduled to be with you here today, and we watch this recording in class, I hope I'll be showing them an example of democracy in action, of elected officials actively listening and changing proposed legislation to better protect Manitobans. We want to see a version of Bill 23 that aligns with the approach used in the ULCC and Ontario Acts, meaning no Section 4.2, to ensure there are no gaps in the protection of individuals and organizations speaking up about matters of public interest. Although the version of Bill 23 that was introduced is not perfect, if I was marking it in my class, I'd give it maybe C+ or a B. It's my hope that we will see the removal of Section 4.2 of the bill today, so I can assign the Public Interest Expression Defense Act the grade Manitobans deserve, which is a big fat A+. Thanks for your time and consideration of my remarks.
Thank you so much. Minister Wiebe?
Yeah, thanks so much, Ms. Fast, for your presentation. Looking to get that A+ tonight, but I appreciate it. You know, your support really means a lot because not only are you representing the Manitoba Eco Network, who lives and breathes this reality every day and really tries to navigate these issues, but your academic work has really lent a lot of credibility to this issue as well. We appreciated the meeting and the opportunity to talk through some of your concerns around Section 4.2, and yeah, we're looking forward to working with you. And thank you again for your presentation, and thank you for the students who are following along and going to watch this later. We hope to see them in committee following your lead and participating in democracy.
Thank you, Minister Wiebe. Ms. Fast?
Thanks. I hope to be back, and hopefully in the future, I will be Dr. Fast instead of Miss Fast, and you can hear about my study results.
Thank you. Anything else? Mr. Balkin?
Well, thank you for your presentation and again, doing the advocacy. I also look forward to seeing the students here in the future because that's what this committees are about, is having that. And it was good to hear finally a passing grade for this government. So, thank you.
Ms. Fast?
Thank you.
Ms. Fast? Yeah.
Thank you. And I appreciate your comments you've made today about the importance of hearing from the public. I very much agree.
Thank you. Any further questions? Ms. Cable, or Minister Cable, my apologies.
Thank you for coming here today, and thank you for being such a phenomenal example to your students. I think that it's so important that we have instructors, professors, folks in positions like yours doing the good work of showing students exactly what this looks like in action. So thank you so much for doing that.
Ms. Fast?
Thanks, and I'll do my best to prepare them for when they come speak to you.
Wonderful. Thank you. I would now like to call upon James Bedham. My apologies if I mispronounced your name. Perfect. James, please proceed with your presentation.
Thank you very much to the committee. Thank you very much to the chairperson. I'm very happy to be presenting here today in support of Bill 23, the Public Interest Expression and Defense Act. I also am going to echo, and I will get into that momentarily, echo some of the comments of the previous presenters that I believe that subsection 2 of section 4 should be removed from the bill. But overall, this is a good bill. I do want to address an opening matter, which I've been lucky enough to present many times to this standing committee. This is a somewhat unique process in Manitoba. I think only one other province in Canada has the process where anyone in the public can come in, and I think we've heard some great comments today, so I'll make a suggestion, which is, I believe the legislative rules provide 2 days minimum notice for getting a standing committee together. I would suggest upping that to a week so the members of the public can have more time to prepare better submissions and better participate in this process. So just as an opening matter, I want to put that on the record once again, and I hope this might be the last time I have to put it on the record because I see changes as a result of that. Now, once again, this is a good bill. It serves to create a legal tool to reduce the risk that legal action will limit the expression that relates to matters of public interest. I'm speaking today as a private citizen, but I will state I'm called to the bar in Manitoba, and prior to a recent career shift about a year ago, I spent 10+ years working as a lawyer, primarily in litigation. A couple of adages that I found myself constantly telling clients over my decade long of practice was, there's no justice in the justice system. And the sad reality of that is sometimes it's a reality that we need changes in the laws, but more often than not, it's the reality of the inequity in the justice system. This bill isn't going to solve massive economic issues, but the reality is the justice system is hugely inaccessible for people. 10, 25, 100,000 goes very quickly. It's just the reality of it, and it makes it inaccessible. I remember advice that I got as I was about to go to my articles from a lawyer was, realize how expensive we are. Even most lawyers can't afford to hire lawyers. So the reality of our justice system is that very often it's for large organizations and very wealthy people. And that's something that this bill provides a small tool that will help improve that. Another adage I often ended up telling people is, even if you ultimately win the suit, just by being sued, you lose in many respects. Once again, that's a cost issue, right? Because the reality is, once you're served with a claim, you have to respond. If you don't respond, default judgment will likely be rewarded against you. The other party's going to get what they want. And even if you do respond and you fight the suit, the reality is that typically costs are awarded on what's known as lawyers call a tariff basis, which means in accordance with the cost tariffs laid out in the King's Bench rules. And you can't say for sure, it depends on how many hours the lawyer will take, but I would suggest that typically that's about half to 1/3 of the actual costs that people incur. And this is why I think in some ways this bill provides some good provisions, specifically Section 6, which provides costs on a full indemnity basis, which means a 100% basis. It also allows for discretion of judges to adjust that award as they see fit. And I want to highlight the discretion of judges because I think that's very important. I want to make it clear that, I want to get ahead of any the sky is falling arguments that might appear, right? Judges are highly competent in Manitoba. They are good at assessing claims, determining the merits of claims. That's what they do. So I think we need to realize that. And I think realize that, entrust our judges to have that discretion. And this bill simply creates the option of moving forward with a motion to dismiss a proceeding where the judge on balance, it's outlined in section 3, I believe, where they sort of outline the balancing weight that the judge is going to take to look on balance. The purpose of this proceeding, is it intended to suppress public expression? Now, I will say that subsection 4.2 should be removed. And I think in addressing that, I want to highlight how injunctions typically proceed, because this doesn't mean we will never see any injunctions. This doesn't mean we won't see people having legal protections. There is simply an additional tool, an additional motion that people can avail themselves of if they're going to move forward. But Rule 40 of the Court of King's Bench rules stipulates how an injunction may proceed. And although it doesn't always happen, I will suggest more often than not, injunctions proceed on a without notice basis. That's the more common than not. So what that means is that the other side isn't there. It's an ex parte proceeding, so the other side doesn't get to make their arguments. And now, although lawyers, we have an obligation to be truthful and honest to the court, we also have an obligation to advance our client's interest. So you can probably understand in an adversarial system when one side presents arguments, the other side doesn't. It makes this certainly creates some procedural inequity. Then a party typically, once they've got that injunction, now they need to respond. They need to deal with the injunction, how it's going to be dealt with. The main action or application, as the case may be, that originates the proceeding is honestly very often nominal. It wouldn't make it into King's Bench in terms of quantum of damages. They're usually trivial suits in nuisance or trespass or maybe detinue. There may be issues of publication. I can't comment on specifics. Each case is unique to its own. But the reality is that the actual claim itself is generally very nominal. And so that's why it's important that subsection 4.2 be removed, because that injunction itself would be a way to continue to drain a party's resources. It in many ways is nonsensical with the over-intention of the bill. And all it would mean is that the party that then has that injunction would then end up having a motion where the judge would ultimately decide the entire proceeding, whether it has merit or not, and whether the intention of it is to suppress public interest. Ultimately, I just wanted to sort of outline that sort of procedural aspect so that I think members of the legislature understand that. This isn't going to change the world, but it is going to make a meaningful impact. It is going to create an option for people when they're facing what is colloquially known as SLAP lawsuits, strategic legal actions against public participation. And it has broad-reaching impacts, as we've heard tonight. Labor disputes and injunctions on labor disputes, environmental issues, publications, broadcasters, journalists, I think the abuse survivors. There's a broad range of categories. Politicians, right? I mean, you were all lucky enough to benefit from parliamentary privilege when you speak inside the legislature, as are parliamentarians in Ottawa. However, municipal councils don't have that same benefit. They don't have that same protection. You may not have that same protection if you're acting outside of your course of official duties and speaking in the legislature. So this has broad-ranging impacts, and it is a good bill, and it will be made a better bill by removing subsection 4.2, and I hope this government passes it. I hope we see this government pass it unanimously, which is what we saw in BC. It shows that there is a strong unanimous support to a meaningful bill, and it would mean Manitoba would be the fourth jurisdiction, as I understand it, in the country, following BC, Ontario, and Quebec in implementing anti-SLAP legislation protection for the citizens of Manitoba. Thank you very much. Subject to any comments you may have.
Thank you. Any questions? Minister Wiebe?
Yeah, thanks very much, Mr. Bedom. Very good to see you again. I appreciated the thorough analysis that you brought to the committee tonight. That kind of insider's perspective, I think, is really helpful for us to understand, the impact that this can have in protecting those folks who are vulnerable. And I appreciate your support of this. Again, we met earlier. I'm happy to listen to your concerns around 4.2. Just as a note, this is one of the bills that was delayed by the opposition, and so I think it's a good question. Whether there will be a unanimous support. I hope that there is as well.
Thanks, James.
Yeah, I also hope there'll be unanimous support. It's why I actually, I thank you for your meeting and took an attempt. I hope it's okay to speak to the other side, so to speak. I hope we don't see it that way because it's about Manitobans, but about understanding the implications of this bill, and that I also want people to understand that as I said, it isn't Chicken Little. This guy isn't necessarily falling. This isn't gonna, it isn't. It's huge. It's important, but it's not going to change everything. It's not going to change the world. Systematic inequality is still going to exist. We're going to have to make massive improvements on our economic system, a number of changes, but it is a meaningful tool. So I hope like you, we can see unanimous consent for this ultimately.
Thank you. Mr. Balkin?
James, thank you very much for your presentation and really putting an expert spin on this for us and bringing that forward. It's actually very persuasive, some of your comments that you're making here. So we thank that. And I'll just add to what the minister said is that, yes, we did hold this bill back, and specifically for the reason that we wanted to make sure it was right. We wanted to check with the experts, and we wanted to check with people within the law and citizens that are being affected. So, it's important to make sure we get this right.
Thank you, Mr. Balkin. James?
Definitely, I agree. It's important we hear this right. I think it's important we hear from Manitobans, which, I made the comments about the process, and so I don't know. I guess I don't really get to ask the questions, but I'm going to ask one anyway, which is sort of, will we be seeing unanimous support? Has decisions been made now that enough time has been there to reflect and consult with experts?
Thank you. Any further questions? Seeing none, thank you for your time. I would now like to call upon Ms. Louise May. She is on Zoom, so Ms. May, I would ask you to turn on your camera and your microphone, please. Hi there. Ms. May, please proceed with your presentation.
Yes, okay. Thank you very much. I appreciate the opportunity to come at this from my home. I was unable to get downtown, and this offered me an opportunity to share my thoughts on this important bill. I am very supportive of it. I would like to see it go through. I know there are some amendments that have been proposed, and I agree with those amendments. I guess I'd like to bring my own personal perspective to it, having just been through quite an involved process, which made a lot of headlines around. But it was certainly a case where this bill would have prevented myself from being the target of a lawsuit and others as well. So we talk about this concept of people being intimidated to come forward and protect their communities, protect the vulnerable people, protect the history, bring forward important concepts that are not being proactively dealt with by our politicians. And that's, I think, where this needs to start. Is that, as we progress as humanity, if we can move forward with more rigorous ethical debate, that we might be able to, circumvent some of these things. And really what it comes down to in the situation that I was involved with, which was the protecting and preserving of the St. Norbert Forest, important forest, LeMay Forest, and the important heritage asset of a graveyard of over 3,000 identified children from the orphanage that was on that site from the early 1900s to 1950. Major historical development, and of course you all know that the province did step in finally and expropriate. In the months that were quite stressful for myself, I will say, and for many others, and the decisions that I had to make as an individual. And I will say that I am also a small business owner. I am 21 years of Aurora Farm in St. Norbert within the city limits. 160 acres, so I manage land, I manage a business, I have a lot of ethical considerations in my business, so I am not coming at this thinking that that other business owners don't go through those same kind of ethical decisions. But when we have landowners, in this case in particular, who are it seems without that sense of community ethics, and that those conversations break down entirely, that what we are left with is literally standing in front of bulldozers, literally holding a fire, a sacred Indigenous fire for months to try to protect and bring awareness. In my own case, in early January, the injunction that was brought on by the owner, the landowner, the injunction, I should say by the landowner's company, so an incorporated company, is able to to create an injunction naming many different people. It named over a dozen people and then numerous Jane and John Does. So that left them open to simply, I wasn't even named on it originally. And some of the people who were named had no idea why they were being named, for instance. So this shotgun approach where a person who has already lost, has already had his proposal turned down at almost every turn, is able to still circumvent all of that and threaten the community by starting to just cut down the trees. And, it's just the bullying techniques and the evidence that was gathered was all illegally gathered. The developer in question had a video camera in his sunglasses, we found out. Numerous individuals got different kinds of letters from the lawyer that were nonsensical and just simply threatening us. I found myself having to hire a criminal lawyer to defend myself in a civil case. Of the 4 counts that were of the contempt, 3 of them were dropped. And the one charge that was, ultimately, I think the most bullying charge was that they wanted me to rescind my private prosecution against the developer and the landowner personally, which was the route I chose to take as an individual to try to stop that, to try to stop the trees from cutting down. And it was a tactic, a maneuver that my lawyer had suggested was something I could do personally. I didn't need to have anyone else with me. I could just go down and file it. And so we did. So this is, and this is coming from for myself, 40 years of activism. I became an activist in my teens, and I have seen many, many different projects and been in different situations. And what we're seeing is this, over these years, is this inch by inch control that has now led us to this situation where, individuals just are afraid to stand up. And many, I can't speak for them personally, but I will say that I heard from many of the other participants in the LeMay Forest how afraid they were and how they were afraid to go out of their homes because other threats were happening, not just legal. I had someone drive by my house a week before my sentencing hearing yelling, "F you, Louise," a man. And these kind of, like, all these other kinds of bullying techniques that kind of surround the legal thing, very unnerving. So, if we want to, and we're looking at sort of a global sense of loss of democracy. And so to me, the only way that we can protect our democracy is to make sure that individuals who have knowledge, who have experience, who are potentially able to view things in a better ethical way because we don't have the same ties and constraints, that we're able to step up and that we're able to be, present. With the rise of the hatred-based communities that seem to appropriate all of the social and maneuvers that we as progressive activists have pioneered and used over and over. This is another affront against democracy that I don't know. This bill is a tiny, we have to pass it. You have to pass it, but it's a tiny protection where we need a much bigger protection from the government. I'm sure you are all wrestling with these things on a daily basis. So I am just here to say, I hope everyone will be united on making sure that this happens. If we had had this in place, I would have been protected. I would not have had to put myself way on the line to do what I had to do to stop the trees from coming down. So I'll stop there.
Thank you for your remarks, Ms. May. Any questions, Minister Wiebe?
Yeah, thanks, Ms. May. Wow, what a story. Incredible. Thank you for sharing. I'm glad that we could step up as a government. We can protect LeMay Forest, and I'm glad that we're moving on from that. But I guess I'm just reflecting on the fact that this bill, again, has been delayed. The fact that Manitoba hasn't had this legislation because it was never considered or contemplated or passed, voted against, I guess is the way to put it, by the previous government. I guess maybe can you just recount again, just detail how this bill, if it had been in place, the kind of impact it would have had on your situation specifically, and the kinds of pressures that you were feeling, and I guess others in with regards to saving LeMay Forest.
Thank you, Minister Wiebe. Ms. May?
Pardon me. So first of all, I think and someone more knowledgeable than me, James, probably knows this, but that provinces that have enacted anti-SLAPP legislation, I would think that those developers or people wanting to threaten would be a little bit more careful, a little bit more reticent to get involved in doing that kind of threatening action against the community. I hope so. There's that kind of preventative measure that right there. I myself am not exactly clear, does this come in where a judge, so I watched the judge in my case, I went in front of that judge many times, and I watched her not have the tools to throw it out. And I wonder, again, James maybe could answer this better, or someone else with a more legal mind, that it gives I would hope that this gives the judges a way to preemptively say, yeah, no, we're not going to allow this to go through in the first place. We're not even going to get to a trial. We're not going to enforce. We're not going to allow this injunction to move forward. So, I think the injunction that was out against us, the whole big group, that I ended up being the only one who was tried for that injunction, I had no basis in fact, and it had no evidence, talking about the individual's participation. It was just a big list of names. And like I said, mine wasn't on it. So even with mine not on it, they were still able to circumvent that and use it as a tool to shut me down, or to attempt to shut me down personally. So I'm not representing any group. I'm an individual. I just knew that, that was what I had to do, because I knew that we don't have anti-SLAPP legislation. I knew that was what they were going to do. They've already proven in several other situations that this is how they operate. So there was no surprise. So to answer your question, I hope it would have curtailed it snubbed it out right from the get-go.
Thank you. Any further questions? Mr. Balkin?
Again, thank you very much for your presentation, and bringing your specific case forward here gives us, again, understanding from many different Manitobans. Thank you.
Ms. May?
You're welcome. Thanks for having me.
Thank you so much. I will move to the next speaker, Ms. Diane Bousquet. She is on Zoom. Ms. Bousquet, I would ask you to turn on your camera and your microphone, please. Ms. Bousquet, can you please turn on your camera and your microphone? Ms. Bousquet, please continue with your presentation. Ms. Bousquet, we can't hear you. Can you please ensure that your microphone is on?
Hello?
There we
Hello?
go. Thank you. Please
I
proceed
am
with your
terribly sorry
presentation.
about that.
Ms. Bousquet, please,
Yep, thank you.
please proceed with
Hi,
your presentation.
Hi, my name is Diane Bousquet, Shining Flowering Thunderbird Woman. I am a Métis woman of Bear Clan, a rights holder and a land defender of the Lemay Forest. I have stood alongside others fighting for the search for Brady Landfill, where communities continue to seek justice, truth, and the return of our missing and murdered sisters. I have also walked from Portage La Prairie Residential School, a place my father survived, all the way to Winnipeg, to the homestead of my mother's ancestral homestead. Every step of that walk was an act of ceremony, prayer, and peaceful advocacy, reconnecting generations separated by trauma, calling this province to remember. These acts in search for our sisters, and on my walk from Portage La Prairie and defending the Lemay Forest, I've been assaulted, arrested, and criminalized for standing in peace. These experiences are why I'm here today. I come before you in strong support of Bill 23. I am not a lawyer or a politician. I am a woman with lived experience of being silenced, ignored, and restricted for speaking the truth, for defending land, for protecting the memory of children, and for standing up for what's right. For years, I've spoken in ceremony and in advocacy for lands like the Lemay Forest, a place of a sacred place in St. Norbert that holds deep cultural, spiritual, and significant meaning for our people. In that journey, I've witnessed how systems have often protected those with power and privilege and not those acting in good faith. I have seen justice systems used as a weapon to discourage truth rather than a shield to protect it. Bill 23 brings hope because it recognizes that public participation, truth-telling, and peaceful advocacy are not threats. They are essential to a healthy democracy and to reconciliation in action. While I fully support this bill, I respectfully ask that Section 4 be amended to include the protection of individuals facing injunctions, restrictions, arrests, or legal orders meant to silence peaceful advocacy or expression on matters of public interest. Right now, Section 4 mainly a civil action like defamation, but in reality, many advocates, Indigenous land defenders, whistleblowers, and communities face injunctions, arrests, and court orders that do more than restrict speech. They cut us off from our lands, our ceremonies, and our sacred responsibilities. In my own advocacy, these injunctions did not only limit my right to public participation, they robbed me of my ancestral rights, banning me and others from our ancestral lands and from conducting ceremonies that have been carried out since time immemorial. These were not restrictions based on harms I've caused, but the discomfort of the truth I was bringing forward. Meanwhile, others have used the justice system through threats, injunctions, and procedural tools to silence those working for accountability. That's why I recommend that the section be amended to include the following language. This act applies to any proceedings that arise from the expression of a matter of public interest, included but not limited to acts of defamation or injunctions, arrests, or orders to seek to restrain or penalize public interest expressions or peaceful advocacy by individuals acting in good faith. This amendment would make sure that the law protects all truth tellers, those who write, speak, sing, or pray for change, not just those who do so through formal institutions or media. This summer, I fasted outside the Manitoba Professional Institute of Planners. That fast was not a protest, it was a prayer. For 4 days and 4 nights, I stood in ceremony for truth, healing, and accountability within a system that has forgotten their humanity. It was about reconciliation with the land, with community, and with truth itself. And yet, even peaceful acts like prayer and ceremony can be misunderstood and met with resistance. Bill 23, if strengthened, this amendment could help bridge that gap. It would ensure that those who are acting from conscience, especially Indigenous women, land defenders, and advocates for transparency, are treated as not as adversaries, but as contributors to justice and healing. This bill can demonstrate what reconciliation looks like in law, protecting voices, truth, and honoring the sacred responsibilities we carry for each other and this land. I urge the committee to pass Bill 23, the Public Interest Expression Defense Act, with the consideration of a critical amendment. The protection of public interest expression is not only a legal matter, it's a moral one. And for far too long, fear has silenced the voices that need to be heard most. With this bill, courage can finally be protected, and truth can once again have a rightful place in public life. Thank you for your time today.
Thank you, Ms. Bousquet. Minister Wiebe?
Yeah, thank you, Diane, for your presentation here tonight. You said you weren't a lawyer at the beginning of your presentation, but I thought you laid out a perfect case as to the importance of this bill. But of course, you did it with heart and personal experience, which I think is probably the most important part of this. I also just wanted to thank you for pointing out your agreement with previous presenters around Section 4.2, and I think that there is a consensus that I'm seeing from presenters and from the public, and of course we're happy to work with you and with the public to make sure this bill is the most effective that it possibly can be. So thank you for your presentation tonight.
Ms. Bousquet?
Thank you.
Any further questions? Mr. Balkin?
Diana, thank you very much again for your presentation. It's important, as I've said to all of the presenters, to hear from Manitobans across our province and all of the different experiences that people have. So I appreciate you taking the time tonight to give us this presentation.
Ms. Bousquet?
Thank you very much for your guys' time tonight.
Thank you very much. I will now go on to Mr. Eric Redder. Sorry if I'm mispronouncing your name. Is it Mr. Reader or Redder? Rader, oh, sorry. Mr. Rader, please proceed with your presentation tonight.
Thank you. Thanks for giving me an opportunity to speak on Bill 23. My name is Eric Rader. I'm the director of the Wilderness Committee. We just celebrated 45 years of standing up for nature and wilderness across the country just in August, and I've been the director in Manitoba for 20 years. A couple things right off the top. I'm standing here to support Bill 23 anti-SLAPP legislation. I think we were looking at, BC brought this in 2019. So it's an important piece to have in place. The other thing before I forget is that Section 4.2 on injunctions, absolutely, I support the removal of that from this bill, from the stories we've already heard. I'm gonna start by telling you a story from 2010 from BC that would have driven the anti-SLAPP legislation. Taseko was a mining company that was going to mine beside Fish Lake. We were engaged with the First Nation whose territory it was as an environmental organization. We're not consultants. We work on a public need basis. And one of the things we did was their application to open up the mine beside Fish Lake. Their Environment Act proposal, what it would be called in Manitoba, stated that over time it was going to contaminate Fish Lake. We published that to our website. And then we got a cease and desist order, and then we got a lawsuit from Taseko Mines because we'd published the words that they had published in their application to the government to open up a mine. So within a few days of that being made public, the public being aware of that, one of the leading anti-SLAPP lawyers in the country walked into our office, Daniel Burnett, and said, "I'm taking this case on pro bono for you." So that was really good, except that we're looking at, losing our organization that had been in place for 30 years because this company is scared of the fact that we published the things they said in public. And the fact that a lawyer stepped forward and helped us was obviously very good, and it indicates that there's public good, there's pieces that we need to work on. What it took for our organization was a complete revamp of what we were allowed to say in public. And it took more than 100 hours of dispositions with this lawyer so that we could clear ourselves through this case. We eventually won the case, which is excellent. But again, it took a lot out of our organization to do this. So then fast forward to 2019, BC has passed their anti-SLAPP legislation. The letter that I've handed out to you is directly as a result of my work in Manitoba. During the pandemic, we're doing some research on caribou in Nopaming Provincial Park. One of the things that I looked on the Mines Branch website is I found mining claims that are inside the protected area. And I'm like, well, that can't really be. Like, who would make this mistake? This isn't possible. So I planned a trip. I took my kiddo out with me, and we paddled out on May Long weekend, and I documented GPS coordinates, photographs, drone footage, everything I needed to show that this mining claim is explicitly inside a protected area, which is illegal. Came home with the documentation, loaded it all up. This is a big deal. And then within a couple of days, I got this letter from the lawyer. So immediately, we're scared. We're trying to figure out how to protect our provincial parks. So when we talk about the personal and what this means, we've heard from other folks who talk about the risks that they've went through. There isn't anybody who speaks up for caribou. There's nobody who speaks up for our provincial parks, and I would imagine that everybody in this room here has fond memories of going and visiting provincial parks, and we lose pieces of those when we don't care for them. And so in this instance, again, Daniel Burnett, we contacted him. It wasn't pro bono this time. We sent over this. I've given you the news release that showed what we said in public and the letter that we got from the lawyer. Very explicitly in Manitoba, the reason we need this anti-SLAPP legislation is so that people can speak up on the public good. If I had said something wrong and I was getting sued because I had defamed someone, that's an entirely different situation. But we're stating the facts about what is happening for the animals on the land in Manitoba. So those pieces are direct. That was all I was going to present on today, but I really want to touch on something that Louise May talked about, and then Diane just presented on. I was part of the LeMay Forest fight for 120 days this year, and it was a hard thing. I would suggest that in January, I got a very terse message from the lawyers for the developer, for the owner of the LeMay Forest. That put me into again, looking for lawyers to hold this up, say, wait, why am I being told to do all this work for this lawyer? This isn't the way things are supposed to go. What I would suggest is that lawyers are, without anti-SLAPP suit, lawyers are emboldened to lash out at people and to pressure people. And they're emboldened because there is no response. There's nothing that people are going to do. So folks who can afford to hire lawyers get to control the narrative. And that happened for quite a while on LeMay Forest, because LeMay Forest was a 5-year battle that only culminated in a real decision being made by this government in the last 120 days. So what we do for public good here, for standing up for any piece of society, whether it's talking about social housing, which has come up here today, or talking about funding or organizations. MJ talked a little bit about what it was like to be in First Nations, be in Hollow Water, and be trying to confront the chief and council about their decision making. I was followed around Hollow Water on that same campaign by the RCMP every single time I showed up in the community. So there's a place where power imbalance exists, and it's up to you as leaders of this province to figure out how to sway the power imbalance back so that we as a collective can look after ourselves, we can look after nature, we can look after climate. And that's pretty much the extent of my presentation today. Thank you.
Thank you, Mr. Rader. Questions? Minister Weed?
Yeah, thanks, Mr. Rader. You know, I got to admit, I appreciated what you shared here today, and it makes my blood boil to hear the ordeal that you've been put through. And you know, we've heard from numerous others, high-profile situations, who've experienced the same kind of thing. So I know that you're in good company there. But I'm just wanted to express, the frustration along with you. You know, what you had to go through. And I'm really happy that we can bring this legislation forward, and I do hope that it gets all party support. We just get this done. I can't believe we delayed it this long. Let's get it done, and let's protect the good work that you're doing. Thanks again.
Thank you. Mr. Rader?
Thank you.
Mr. Balkin?
Thank you, Eric, for your presentation and really bringing what you had as firsthand experience forward on this. So. Again, I know the minister said it several times that this was held back, but for good reason. We want to make sure that the legislation is proper and meets what everybody is looking for. So thank you for being here, and thank you for your presentation.
Mr. Rader?
Yeah, thank you. I would say that the more indication that people see in public of people working across the aisle, the easier it will be to turn down rhetoric, the show of support behind things like anti-SLAPP, which really goes to empower citizens to be part of their society. Things like, again, climate legislation, having people from both sides of the elected House, from all three parties in the elected House, standing together and passing messages on to the public instead of looking for ways that they can be political. Some of the things are much more important than who's going to win the next election, because we're running out of time for caring for society, nature, and climate. And you guys are in the seat right now, and we're going to be looking back and remembering that you guys had that opportunity to collectively get together. This is the time for you to do this. Thank you.
Thank you. Any further questions? No. Thank you for your time, Mr. Rader.